Hello, hello, hello. Welcome back to the Civil Point Podcast. Why did I almost forget the name of my own podcast? My name is Ariana Dieva, and if you guys haven't already, you guys can go ahead and hit that subscribe button. That way you guys don't miss out on new content, new lives, and new information when it comes to literally practically, it's sad to say, but the destruction of the United States as we know it. But what we will do is fight to make sure the destruction of the United States of America does not happen, because everyone here that lives in this country on this soil is important, not just one group of people. And we have seen it in the past before, and especially in the last 50 years, the advancements that America has made in marginalized communities that also helped the development and infrastructure of America itself. So today we are talking about something that is very scary, because a lot of people think that we overreact. A lot of people say, well, those are just words. You're taking it out of context. These are just statements made by someone. It's not really how they truly feel. But when those statements directly target a group of people, it is very, very, very normal to think that there's no coincidence or mincing of those words. Because if someone didn't feel negatively about a certain group of people, a marginalized group of people, then those words wouldn't come out of their mouth. It's just very simple math. 1 + 1 = 2. Instead, people get 1 + 1 = 55. You're taking something out of context, and that's not true. And what I want to talk about today is something that I find really unsettling in our justice system and in the political landscape, as well as just in general, people in the United States in general. We are in a really weird time and space where facts and reason don't matter over political affiliation and loyalty. And that is a big problem for me, not only just for me, but people of marginalized groups of communities. And when I think about the statement and the topic I'm going to talk about, it's going to, again, relieve a broader topic that not all rights are inalienable when it comes to the United States, when it comes to marginalized groups of communities. And I had an interaction maybe about, I think this was July 4th. July 4th, I believe this was. My boss had sent out an email stating that we have to, even though we know the current landscape of the world, the United States of America, we have to be grateful for the rights we do have. And I found that a little bit nuanced, and I don't want to say hypocritical, but nuanced to say when the rights that are being stripped away from people do not affect a white man in America. So to sit here and say we have to be grateful for the rights that we do have kind of rubbed me the wrong way, because I was like, you're not at risk of your inalienable rights or your right to exist as a white man being stripped away. You're not at risk for that at all, ever. You'll be okay. But people like me, people like my neighbors, people across the country, everywhere in every sector, like Spanish people, Hispanic people, Black people, gay people, bisexuals, lesbians, trans, every marginalized community is affected by what is currently going on. So as a white man, to sit there and say we need to be grateful for the rights we do have when your rights are not at stake or at risk of being torn away from you, I think that's a very just nuanced and hypocritical thing to say, because you don't have any risk when it comes to our constitutional rights being stripped away. So, what I want to get in today is straight up, our court sent a warning shot to the LGBTQ plus community. A straight warning shot for this community because they are coming for your rights. We said they were going to come for Roe v. Wade and abortion, and they did successfully. And now they are taking a warning shot, and more specifically, Justice Clarence is giving foreshadowing of what is to come in this term for President Trump in the next now 3.5 years. So, I honestly 100% believe that they are gunning for LGBTQ plus rights because it was a warning shot taken by Justice Clarence Thomas, in a Catholic church. That is the crazy part of it. It was a straight warning shot to the LGBTQ plus community, and it was taken from a Catholic church. So, when we think about LGBTQ plus rights and everything like that, we know that religious communities want to alter the definition of what marriage means to not just man and woman. They want to codify the term of marriage between man and woman instead of person and person. And we know that our government has made significant turnover in regards to how we address marriage in the United States. So yes, we have the Respect for Marriage Act. Yes, we have decisions regarding Obergefell v. Hodges that solidify that marriage equality is a given right in regards to our Constitution. So when I look at the direction of the court currently right now, I do see the manipulation of the scope of our court system. I do see the manipulation of the political landscape and the weaponization of our government to use our court system to marginalize groups of communities to a point where their rights no longer exist. And this is the scary part, because we do have the Marriage Equality Act and we do have Obergefell versus Hodges that sets precedent. But there is a specific statement that Justice Thomas Clarence stated that has me worried and that made me think this was a clear warning shot and a foreshadowing that the Supreme Court is going to go not only after gay marriage, LGBTQ plus rights community to marry, but also I think they are going to go further and aim for the restriction of gay intimacy, whether it's public or in your own home private. And I know they want to say you're going to be overreacting, but it's not overreacting when the writing is on the walls, when our justices are compromised, and when our president of the United States literally does not care what happens to half the country, and he only cares what happens to his MAGA supporting base. So yeah, I have every right to be afraid and to be petrified. And you have every right to be afraid and petrified that certain inalienable rights that have literally been only available for a certain group of people for 10 years could be now overturned and restricted because of the political landscape and the weaponization of our government through Christian nationalists. Yeah, you do have every right. So let's take a look at this warning shot that I'm talking about. So, 1 minute, I'm going to pull it up here. Pulling it on up. Last night, I was scrolling. Scrolling. And I saw it. And I was just like, oh my God, this is kind of crazy. All right. Wait, where is my whatchamacallit? Where is my... Here we go. Boom. Okay. We have it up. Perfect. Okay. All right, so I was scrolling. I thought I had things set up, but apparently not. But this was really big news to me because when a justice attempts to right a wrong, they're going to send warning shots. And this is what the warning shot was. Justice Clarence Thomas said the Supreme Court should take a more critical approach to settled precedent, saying decided cases are not the gospel and suggesting some may have been based on something somebody dreamt up and others went along with. This is a scary, scary statement from Justice Clarence Thomas. So this article is from ABC News. It's written by Devin Dwyer. And not only that, so when we take a look at this statement by Justice Clarence Thomas, he's giving a warning shot. He's giving foreshadowing that nothing in our Constitution, nothing in case law, nothing that is required in regards to inalienable rights and freedom and bodily autonomy is ironclad, is codified in our justice system. He has made that very clear in his stance on LGBTQ plus rights. And now that we have an overwhelming majority in the Supreme Court that is conservative, you can guarantee, just as Roe v. Wade was on the docket to be terminated and ripped apart, that LGBTQ plus rights will also be on that docket. So, in this statement, he says that decided cases are not gospel. And when you take a look at that statement, you're like, oh, okay, whatever. But when you look at the trajectory and the aim of this Supreme Court to bring us back to the year 1860, it's a concerning statement because that does not only go to LGBTQ rights. It goes for every minority community. It goes for what's the word I'm looking for? It just went out of my mind. It attacks interracial marriage. It attacks every precedent that is set through case law that could possibly gain any sort of freedom for any sort of marginalized group of community. So when you're saying that the precedent isn't gospel, the gospel is considered God's word. The gospel is considered ironclad. The gospel is considered you're going to live this way. But he's saying that the decisions that have been made by previous courts can be brought up, can be argued, and can be overturned, including gay rights. So, it's no longer settled precedent when it comes to the gospel. So when we look at this article, it says Thomas made the comments during a rare public appearance Thursday evening at Catholic University's Columbus School of Law in Washington, D.C. And this is why I say it's foreshadowing. This is why I say the statement by Justice Clarence Thomas is literally a warning shot. I mean, when we look at the issue and the debate of marriage in the United States, religious institutions consistently try and remove and say that we are infringing on the right to marry between a man and woman because we are changing the definition legally of what it means to marry to a person in person. So when Justice Clarence Thomas is delivering this statement that decided precedent is not gospel, he is straight up saying from inside a church that the major issue with Catholic Church and religious institutions is LGBTQ plus rights and the right to marry. So saying that from inside a church is foreshadowing that the Supreme Court is coming for LGBTQ plus rights. And you can't say I'm overreacting. You can't say that we are taking things out of context, because when a Supreme Court justice is here saying straight up, nothing is precedent, nothing is set in stone when it comes to inalienable rights, you can guarantee, especially with a judge that has a track record and a history and a consistency of standing against LGBTQ rights, saying that precedent is not gospel from inside a Catholic church, he is coming for LGBTQ plus rights. And there is no doubt about it. So, I wanted to take a look in regards to the actual decision that gave pathway for the right to marry for LGBTQ plus people. when we talk about the pathway, it is very hard when it comes to understanding LGBTQ rights. I mean, they've been a marginalized community for centuries, and then in the United States for literally decades. It's been wrong to be gay. It's been wrong to be lesbian. It's been wrong to be trans. And just recently, over the past 10 years, we really had that right to excavate that antiquated ideology of being gay is wrong, to the point where marriage was now accepted in the United States. And these antiquated ideas we thought were tiring out, but we understand now that these antiquated ideas were just settling down until they had the power to possess and invoke their own religious institutions through our government and through our law, conflating their gospel with actual constitutional legalities and illegalities. So, when we look at, I'm gonna pull this up here. There's a huge, I'm just pulling this up. There's a big misconception when it comes to Obergefell v. Hodges. This is the landmark Supreme Court case that literally gave pathway to gays the right to marry. And a lot of misconceptions from religious institutions is that this decision changes the definition of right to marry, as well as infringes on the church's actual ability to refuse to marry a gay couple. And that is a misconception, and it is completely a falsehood, and it is untrue. And I want to go through this because there's this specific section in Obergefell v. Hodges that clearly explains the scope of what it means, the right to marry, and where religious actual expectations are not infringed upon. So, when we look at this, let me just make sure this is up on my screen. When we look at this section from Obergefell v. Hodges, this is from the opinion of the Supreme Court in the court case. Finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths, and to their own deep aspirations to continue the family structure they have long revered. The same is true of those who oppose same-sex marriage for other reasons. In turn, those who believe allowing same-sex marriage is proper or indeed essential, whether as a matter of religious conviction or secular belief, may engage those who disagree with their view in an open and searching debate. The Constitution, however, this is the important part, the Constitution, however, does not permit the state, to bar same-sex couples from marriage on the same terms as accordance to couples of the opposite sex. So this is a very important segment and fragment of the opinion in Obergefell v. Hodges, the decision that literally gave the pathway to marriage equality and same-sex marriage in the United States. There's a lot of misconceptions when it comes to the actual intention of this act and how it's being perceived. Religious institutions perceive that Obergefell v. Hodges infringes on their right to marry. They believe that it's forcing them to marry gay people. And this excerpt proves it to be untrue. This excerpt basically says religious institutions still have a right to their gospel, quote unquote, in regards to Clarence Thomas's phrasing and vocabulary. They still have a right to their gospel. They still have a right to not marry gay people in their churches. They still have a right to refuse to marry gay people by a pastor or a priest in one of their churches. It's still there. You have a right to refuse gay marriage in a church. But the difference is that statewide, states our constitutional, our legal system wise, has to validate and actually adhere and notice and see that these marriages exist in a legal capacity. Whether a church marries them or not, you still have the right to refuse to marry a gay couple in a church. But when it comes to legalities, statewide and federal-wide legalities, you as a church, you as a state official, I should say, as a state official, like Kim Davis, we're going to get into her, you have no right to refuse a marriage license based on the fact that the couple is the same sex. So this is the important part and the distinction of Obergefell v. Hodges, because it distincts that religious institutions still has a right to abide by their gospel, by their book, by their Bible. They can still refuse to marry people in a church. A pastor can say, no, I don't feel comfortable about this because my religion does not promote this and does not require this, so I don't need to do it. But statewide, our states need to recognize gay marriage. And I think that is the biggest misconception of Obergefell v. Hodges, because it states, and the misconception in regards to religious institutions state that we're infringing on their right to marry. We're infringing on changing the wording in regards to marriage. And that is utterly not true. So when we talk about more legalities of our system, we have to talk about none other than the Right to Marry Act, the Respect for Marriage Act here. So with LGBTQ marriage on the docket, always comes the question of legalities, especially when a court case can be overturned. A decision and a precedent can be overturned. But when it comes to actual acts and laws of our nation, that more so codifies our actual position as a nation as what is deemed legal and not legal versus a court case that can be overturned or argued. And this is where the distinction of why I think it may be impossible for our justice system to overturn Obergefell v. Hodges and remove the right to marry for gay people. I think it's highly impossible with the political landscape that we are currently in, and how our court system is manipulated, and how our Supreme Court is beholden to nothing but a tyrant. It is very hard to believe that these laws and these cases that set precedent are not up for debate. So when we talk about the Respect for Marriage Act, this act basically provides statutory authority for same-sex and interracial marriages. This basically removes the terms of marriage between a man and a woman. It just retroactively says we're not abiding by that antiquated theory. It's no longer man and woman, it's between person and person. The act also replaces provisions that do not require states to recognize same-sex marriages from other states with provisions that prohibit the denial of full faith and credit or any right claim relating to out-of-state marriages. So when we talk about legalities, and especially state-to-state legalities, state laws differ from each state. So one law may be available in one state, but one state may not recognize that law. And when you take those laws and there's a controversy between recognizing what law supersedes or hierarchy of the actual between the two states, you go to court for it. It's called, you gotta make sure that people's liberties and rights are just. So you go to court to argue the state laws. In regards to this basically blankets LGBTQ plus rights in regards to a right to marry throughout each state, saying that even if your state has state laws that don't recognize gay marriage federally, our law of the land recognizes gay marriage. So this is the importance of this bill, the Respect for Marriage Act that was codified in 2022, versus the decision of Obergefell, which was in 2015. That's the two differences between them. The act codifies, the actual case gives way a pathway. So now I want to turn to none other than Kim Davis. So Kim Davis is a former Kentucky county clerk. So I feel like my mic keeps popping, even though I have my, not me messing things up. I feel like my mic keeps popping. So Kim Davis, this is a very important, well, not a very important person. No, like, cares about her. She has like 5,000 marriages under her belt, and she's coming after gay people. Like, go fix your own home. Make sure your closets are put together in your own home with your multiple marriages versus coming after gay people. Anyway, Kim Davis has appealed the U.S. Supreme Court to overturn the 2015 Obergefell versus Hodges ruling, which established marriage equality. Basically, she had to pay damages to a same-sex couple after refusing them a marriage license, because on the basis of her religious faith, she is said that she doesn't feel comfortable. My religious faith does not deem this. So the refusal of the license itself was in question because technically statewide and freedom-wide and equality-wise, she had to deliver that marriage license to this gay couple. She could not use and hide behind her religious beliefs to discriminate against a gay couple that was legally looking to have a marriage license that deems them as married and gives them benefits of being married through our legal system, because she just said her faith does not allow her to marry gay couples. But she wasn't marrying gay couples. She was just giving a marriage license to legally give them the benefits of being married. So that's where Obergefell v. Hodges comes in. But when you talk about why overturning Obergefell versus Hodges is highly unlikely, in a normal landscape, say if we were in 2025 and Kamala Harris was our president, it would be highly unlikely that the LGBTQ right to marry, gay marriage right to marry, would be challenged, would be overturned. It would be highly unlikely. But because of the political landscape we are in and the compromised and corrupt court, it is very possible that the right to marry for gays may be restricted, repealed, and even go further to the point where we may, as gay people, you may not be able to even have gay intimacy in your own privacy of your own home. That's where I feel like our court is headed. And I know that's extreme, but to avoid the extremes, you have to think of the extremes. And especially when our Supreme Court is sitting here saying that, hey, we went after Roe v. Wade, we're going to go after gay marriage, with a clear warning shot from Clarence Thomas. It is highly plausible that they are going after gay marriage. So even though overturning Obergefell is unlikely, the Respect for Marriage Act exists, which codifies that as law in the United States, but laws also can be changed. Public support also is very high when it comes to LGBTQ plus right to marry. Gay marriage is seen as a bonus, as a benefit to our community. It also provides a home for children with two parents. And I know the religious belief is man and woman, but when you think about the ability of two parents, my grandma did it all by herself, raised an amazing child, raised amazing 6 childs, and then raised an amazing, well, I was going to say 2 grandchildren, but 1 grandchild, me. But it's there. And when you come to legal precedent and state laws, it's highly unlikely that, or not even state laws, federal law, it's highly unlikely that this would be overturned. But what makes it very scary is a few weeks ago on The View had Justice Sotomayor on, and she said something very concerning. And this is why I feel our justice system is corrupt. Our justice system is at a point of breaking. Upholding precedent does not matter when it comes to this justice system, when it comes to this administration. Upholding equality does not matter when it comes to this administration. We've seen it through the repealing of DEI acts federally. We see it through the repealing of the Equal Opportunity Employment Acts. Equality does not matter to this administration, and we've seen it over and over and over again. So when it comes to the corruption and manipulation of our Supreme Court, it is very likely in this day and age, because Donald Trump is president, that marriage equality is on the docket for termination in the United States. And it's the truth. And I know that's a scary truth, and some people don't want to hear it, but now's not the time to ignore potential facts. Now's not the time to ignore potential actions when you see the writing on the walls. We need to stand up now as a country and say, you cannot do this to a marginalized group of people. You cannot take away and restrict rights that benefit one group of community and remove it from another. And that's where, in regards to marriage equality for me, it hits differently, because marriage equality isn't just a religious institution. It provides actual social benefits as well as tax breaks when it comes to marriage. So why should only marriage be restricted to a man and a woman when other people have relationships they should be afforded through our Constitution and our equality of our Constitution? They should be afforded those rights as well. And that's where the disconnect comes for myself, because I'm just like, how can you sit here and say, and obviously it comes from a religious nationalist point of view, but how can you say that you deserve something and someone else doesn't because they are not in the same capacity as you through your own language? It just doesn't make sense to me. The United States Constitution is based on freedom. Our amendments is based on inclusion. And our overall dignity as a country is based on the right to be you, the right to literally, as the Declaration of Independence says, our right to freedom, liberty, and happiness, the pursuit of happiness. And if you are in a gay couple and your pursuit of happiness is marriage, who's to stop anyone from saying you can't have that when it's available to someone else? That's called hypocrisy. And more importantly, that's called discrimination, which again, our Constitution looks to prevent, and our amendments look to prevent, and our state laws looks to prevent. So, I wanted to go ahead and look at this clip from Justice Sotomayor when she was on The View, and it gave me a little bit of anxiety because, again, it puts this clip from Justice Sotomayor puts into perspective the view of our Supreme Court currently. And when she said what she said in regards to precedent and challenging the actual laws and Constitution of the United States, she basically said everything is up for grabs. And this is scary coming from Justice Sotomayor, someone who is in the Supreme Court, someone who hears what's going on. She, again, gave a very clear warning that everything is on the docket when it comes to this administration. Let's go ahead and take a look. Let's get this on up here.
Is weighing in on the biggest legal issues of our time, from immigration to guns, education, and even the limits of executive power. Now, I know you can't talk about the specifics, but knowing the weight a Supreme Court decision holds, what has surprised you the most about the court?
How hard each case is. Now, when you read a majority opinion, it sounds totally convincing. It does, because for you to sign on to a decision, you have to believe what you're signing on to. Read the dissent, read the other side, and it will tell you how hard these questions are. Don't ever think there's a simple answer. There isn't. First of all, the cases come to the Supreme Court only because judges across the country have disagreed, what we call a circuit split. Reasonable people of all backgrounds have disagreed. And then we get the case. So there's no easy answer.
It's always been like that, right?
Always been
Nothing
like
new.
that.
Yeah.
No, it's not. It's nothing new. Maybe the outcomes are new sometimes, but not the process. The process is hard. And the other thing is,
This is important.
there's no winning.
There's
in
no
court.
winning.
There's one side wins, another side, what's the opposite of win? Loses.
So this is very intellectual on Justice Sotomayor's end, because it's the truth. There's no winning in court in regards to the grand scheme of things. Someone wins, someone loses. And unfortunately, when it comes to rights in our country, if personal liberties and rights loses to religious persecution of those rights, there's no winning for the grand majority. You know what I'm saying? There's no winning for the actual people whose rights are being restricted or taken away from. And when we look at our Supreme Court cases, it's true. There's no true or easy answer. This is why our court system exists. Our court system exists because they look to find answers to... Our court system exists because our court looks to find answers to niche situations that develop under law. They look to provide answers and guidance in regards to those situations, and that is the God's honest truth. So when Justice Sotomayor is sitting here saying there's no easy answer, no one wins because it could change the trajectory of so many people's lives in the country. It is the truth. There's no false about that. Let's continue.
And the person who loses is losing something they thought it was important.
Correct. And that's what I want to say. When it comes to religions and religious people, they believe they're losing their right to practice their faith, to be loyal to their God when it comes to marriage equality. They think that man and woman is marriage. They think those are the definitions of marriage. And when you take that away from them, which technically you're not taking it away from them, because the Obergefell v. Hodges opinion says, if you look at it clearly, you have the right to marry, you have the right to marry man and woman, and you have the right to refuse. As a religious institution, you have the right to refuse to marry anyone who does not fit that mold. But statewide and constitutional-wise and country-wise, we cannot discriminate against two people who look to be married to abide and have the benefits of what it means to be married in our country. So,
Right they had, a claim they thought justified. It is something that's costing them. This is always a price we pay.
correct. And religious institutions think that the price to pay is their religion, and that is untrue when it comes to marriage equality and the Obergefell v. Hodges Act. You have the right to refuse to marry people in a church, but you don't have the right to refuse as a state official to grant a marriage license to gay people. That's where Obergefell and the misconceptions of that decision comes into play. And the right and the conservatives use that card when that card is non-existent because it's a falsehood of the actual decision. No one is infringing on your right to marriage. No one is infringing on your definition of marriage. You can keep your definition of marriage, but when we talk about state and legalities of it all, you have no right to decide as a religious institution what deems equality through our state when your actual Bible and gospel actually discriminates against people. That's why there's supposed to be separation of church and state.
In court cases. So that, yes, that surprised me. I had
Very
no
thoughtful
idea.
answer. Thank you.
No. I thought when I was on the lower courts that it was easy because somebody was above me to correct our mistakes, my mistakes. Not now.
The buck stops with you.
The buck stops with us, yes.
Well, Justice Sotomayor, speaking of dissents, which you seem to be writing a lot of lately.
More than I ever hoped.
Yes. In Dobbs, you warned that overturning Roe v. Wade would create a stench that the Supreme Court's decisions are driven by politics and not law. And in your recent dissent,
Which is
you
true.
said the court's recent ruling would allow agents, ICE agents, to detain people just for looking Latino or speaking Spanish. Why do you see these decisions as so dangerous to our freedoms? And what do you think ordinary Americans should take away from what seem to be very prescient warnings?
Well, first of all, read the decisions.
Correct.
And not just my dissents.
Okay, perfect. I love that. Read the decisions. Justice Sotomayor really put into perspective with that one claim. Read the decisions. Read the decisions of the Supreme Court. Go actually investigate. Go actually use your cognitive and critical thinking abilities and read the decisions, because our opinions of the Supreme Court just don't state, hey, this is what our decision is. It actually gives you contextual background reference on how the court reached their decision and why they reached their decision to, say, grant marriage equality, which we'll get into in a little bit. But this is very important. The misconception of Obergefell v. Hodges, like I keep saying, is that it infringes on religious institutions' right to marry. And it's basically, the misconception is they're being forced to marry gay people. And that's a completely false misconception, because I just read the literal context and words and vocabulary that is provided in our Obergefell v. Hodges opinion. So read, critically think, and understand that not everything is as it seems.
But the other side,
do your
too.
own research.
Become informed citizens and not just reactive, because people will say things that are simply not there, or say things and misconstrue them. Read them
Misconception.
yourself.
Read them.
Educate yourself as Americans. The price we pay is whatever is happening today. As I indicated, it's going to affect a lot of people, but it affects your future. And it affects the conduct of leaders in the future.
And it affects
because
your neighbors.
what we permit today is not going to be duplicated exactly tomorrow. It's going to be something different. It'll be a different group of people. It'll be a different situation. But once we've approved it, it sets a precedent that can be, in your judgment, because in the end, you're the people affected, right? Really bad. And that's what's at risk, is in each time we change precedent, we are changing the contours of a right that people thought they had. And once you take that away, think of how much more is at risk later, not just in this situation.
Exactly. And when it comes to rights being taken away, we look at our amendments. They add rights, they add context, they add equality, they add rights to marginalized groups of people to exist within our country. And our amendments and our Constitution is there to protect and safeguard those rights for every marginalized community, whether you're Black, whether you're white, whether you're Latino, whether you're naturalized here, whether you were born abroad. Everyone in our country and on our soil has rights. No one is immune from protection from our Constitution while you're on U.S. soil. And that is the God's honest truth. And when you have justices and corrupt government officials and completely corrupt presidency going on and infiltrating our government to remove those rights from marginalized groups of people, it becomes a problem. Because as Justice Sotomayor said, when you remove those rights, what else can be taken away? When you remove rights that look to provide freedom and equality, well then if you restrict and remand and remove and revoke those rights, look what else can be taken away. When you look at Roe v. Wade, which is the really first major decision this presidency and administration looked to remove and revoke, and was successful in doing so, it gave them now an inch to now move a mile and go for our next move, which would be LGBTQ plus marriage equality.
And we know that you can't comment on legal cases pending, but as Sonny said, you know, the ruling yesterday about ICE raids, I'm just curious, how are they going to know who is who?
Read my dissent.
Where can people find these dissents? Because I think people always think they're not available to regular folks. Is there a place to how?
Online.
Online.
And you search online the way you search anything.
Just the
The Supreme Court's decision yesterday. You can start there.
Yeah.
All right. Sotomayor dissent yesterday. Nome, that's one of the names in the case. The Nome Supreme Court decision. Search bar, it'll pop right up. The Supreme Court website, supremecourt.gov, has all our decisions immediately when they're issued. So you don't even have to wait
They
for
keep
the first.
defunding the Department of Education. How is going to be?
I want to ask you, obviously, the 22nd Amendment prohibits somebody from seeking a third
Here we
term
go.
in
This
office.
is important.
Do you believe the 22nd Amendment is settled law?
The Constitution is settled law.
Yeah.
No one has tried to challenge that. Until somebody tries, you don't know. So it's not settled because we don't have a court case about that issue.
So this is what is very scary to me in regards to her answer for this. She was specifically asked if the 22nd Amendment is. When she was specifically asked this question, she didn't say yes. She just said, well, anything is up to interpretation, anything is up to arguments, and anything is up to discussion to create a new decision. And that is what is scary about this, and how this certain fragment of her interview, I am hearing a buzzing. I'm sorry, I'm having like technical difficulties today. Anyway, this specific fragment of her interview is very telling. That basically saying anything that's in our Constitution, anything that's in our amendments, anything that's in our laws that guarantees freedoms, anything that has literal law and case law to back it up, to set as precedent, to safeguard our country from creating a tyrant or a dictator, to safeguard our country to creating equality and rights for people to exist, is at stake in this administration. And she said, just because there isn't a case about it, or just because there even is a case about it, doesn't mean that it can't be argued and overturned. And we saw that in Roe v. Wade, when women's health care was now ripped away from women who need and could possibly need abortions, whether in early term or late term pregnancies. So this is why I say the landscape of our political justice system is manipulated, is corrupt, because it's politically motivated instead of legally motivated to create equality and fairness for our United States citizens. And that is the truth. And she says it in this actual clip. She literally says, if there's not a case about it, well, then we don't know, because it hasn't been argued. So when it comes to Trump and attempting a 2028 election run, well, it's a possibility, because the law states, hey, you know, no running for a third term. But then in general, there's no one who tried to challenge that. So when it comes to our Supreme Court, yes, you can challenge previous cases, previous decisions and opinions, but it's up to the Supreme Court to hold precedent. And this is where our Supreme Court, and where Justice Thomas saying that precedent isn't gospel, becomes a serious major red flag and a warning shot to the LGBTQ plus community in regards to specifically marriage and the equality of marriage, as well as not only marriage, but gay intimacy. Everything is at stake because Donald Trump was elected president. So let's get into this here. I want to take a look at originally what barred same-sex intimacy, and that would be Lawrence v. Texas. Go on here. So Lawrence v. Texas prohibited same-sex marriage correct. All right. I thought I was reading something completely wrong there. Yes. So if we look at this, Lawrence v. Texas prohibited same-sex marriage that would be constitutional under... Oh, wait. No. I'm sorry. Boom. This is what I wanted. I was like, why am I reading this wrong? So Bowers v. Hardwick. This is the decision from the Supreme Court in 1986 that overruled Lawrence v. Texas. Basically, Bowers v. Hardwick prevented why am I not thinking correctly right now? Bowers v. Hardwick criminalized same-sex intimacy. Anything revolving same-sex couples, it prohibited it in 1986. And then look who supported it. I don't think Clarence Thomas was on the Justice Department here. 1 minute, the Supreme Court. This is where it is. So, Bowers v. Hardwick criminalized same-sex couples for involving in same-sex acts. Lawrence v. Texas then overturned Bowers v. Hardwick, and if we look at the dissenting opinion of this case, Lawrence v. Texas basically allowed consensual conduct between same-sex people. But the dissent is Clarence Thomas, and Clarence Thomas has been pretty consistent, or overall 100% consistent in his dissents when it comes to same-sex couples, same-sex marriage, and same-sex intimacy. So he's trying to take us back to 1986, where same-sex intimacy wasn't even legal. You couldn't even do it privately in your own home, let alone get married in public. So Clarence Thomas dissents. Although he agreed with Scalia's dissent for the most part, Thomas felt obliged to write separately to point out that the law was silly and should be repealed, but he could find no constitutional basis for a right to privacy or other foundation for striking it down through the courts. So Justice Clarence Thomas has overall been consistent in his view on LGBTQ marriage, and it's to remove it. It's to remove it from the public hemisphere. It's to remove it from our world. It's to remove it and make sure LGBTQ plus people don't exist in their own decisions and actions. That is Clarence Thomas's opinion. And he stated that when he literally said that precedent is not gospel. I don't know why it keeps buzzing. I'm sorry. I'm hearing buzzing in my ear. I apologize. Clarence Thomas said precedent isn't gospel. And he is saying that from a Catholic church, which knows it is a foreshadowing and a clear warning shot that Clarence Thomas knows that what's on the docket is LGBTQ plus rights. Not only the right to marry, but the right to engage in intimacy and privacy in your own home. That is what the Supreme Court is coming for. Your right to action in your own home, privacy. And honestly, that is a whole nother can of worms, but that goes to the right to privacy. And it's just, what this court is doing is upsetting. What this court is trying to put forth is very sad. They're trying to break the human rights of it all. They're trying to codify the removal of rights through anything possible now that they're in power. So I want to mention the beginning of Obergefell v. Hodges, because this is very important when it comes to understanding, like Sotomayor said, why the decision was made by a court, and the opinion allows us to understand a court's decision. There's a specific reference to the court's decision in Obergefell v. Hodges that I want to quote here. I just need to find it because I didn't download it to a PDF to highlight, of course. Why didn't I do that? Petitioners filed the suits. Petitioners, where does it say Confucius? Here we go. All right. So in decisions and opinions of the courts, they will overall give you a reasoning of how they came to their decision. In regards to Obergefell v. Hodges, it gave them the decision and gave a pathway to equality when it comes to gay marriage. So when you look at the decision, in the beginning of the decision, it gives a background of previous institutions and how they viewed marriage and how marriage could be equatable to equity for not only the two people, but a family as well as a community. So when we look at this, the centrality of marriage to the human condition makes it unsurprising that the institution has existed for a millennia and across civilizations. Since the dawn of history, marriage has transformed strangers into relatives, binding families and societies together. Confucius taught that marriage lies at the foundation of government. This wisdom was echoed centuries later and half a world away by Circio, who wrote, "The first bond of society is marriage, next children, and then family." There are untold references to the beauty of marriage in religious and philosophical texts spanning time, cultures, and faiths, as well as in the art and literature in all their forms. It is fair and necessary to say that these references were based on the understanding that marriage is a union between two persons of the opposite sex. That history is the beginning of these cases. The respondents say it should be the end as well. To them, it would demean a timeless institution if the concept and lawful status of marriage were to extend to two persons of the same sex. Marriage, in their view, is a by the nature of gender-differentiated union of a man and woman. This view has long been held and continues to be held in good faith by reasonable and sincere people here and throughout the world. So, I love that they quoted Confucius as well as Circio, because when you look at those time periods that these individuals existed, yes, there was marriage between man and woman, but when you look at the time periods, gay activities still happened. Gay activities still were a part of their society. I don't know for a fact that they denied same-sex marriage, but the overall majority of marriages, because straight people are the overwhelming majority, straight marriage existed. That was the standard. That doesn't mean that was the overall law of the land when they existed. It was just a standard because straight people outweigh in population more than gay people. That does not negate that gay people could have been possibly married in that time period. And that is the honest truth when it comes to it. So quoting Circio, quoting Confucius, in this sense is saying that, hey, we understand the nuances as well as the importance of marriage, but that importance should not only go to same-sex couples. We now need to argue and understand that marriage and its benefits, not only just communally, but socially and individually, should and could and does extend to same-sex couples. So that's where I think this decision is a very specific in how they came to their decision of Obergefell v. Hodges. But, yeah, they're coming for it. And that is my God's honest truth and opinion. They are coming for same-sex marriage, and they are coming for gay intimacy. And that is the God's to honest truth. So, the only way to fight this is to tell your stories. The only way to have people gain understanding and knowledge of why LGBTQ people exist and how gay marriage can help communities, help individuals, provide benefits to people, just like it provides benefits to different sex couples, is to tell your stories. And that's the only way to sway public opinion that gay marriage is available and beneficial to society. The only way to expose people is to tell your stories. So that is what I want you to do. Like, if you have your story of gay marriage, how it affected you personally, how it affected your family, how it affected your community, tell your stories below, because that is the only way that we expose the truth that gay marriage is nothing evil. Gay marriage is not looked down upon, and it should not be discriminated against. It should not be held to a standard that is below the standard of opposite sex marriage. gay marriage is available and it is beneficial to families. When I think of same-sex marriage, the arguments tend to be, well, you need a mother and a father in a home. And I say, well, that's not true. I was raised by a single grandmother. I was raised by a grandmother who chose to raise me. And in her choice to raising me, she not one day complained about it. Not one day, to my face at least, but not one day complained about it. She chose it. She gave the opportunity to me not only to raise me, but to show me how life works, to show me how to succeed in life. And that's where I am today. I mean, she would be so proud of me that I got my associates and now I'm working on my bachelor's in legal studies. So I just think that the antiquated ideas of marriage, the antiquated ideas of this religious belief can still be institutionalized in your religion. But when it comes to the legal world and the justice world, you cannot infringe upon people's inalienable rights and right to pursuit of happiness because your religious text says otherwise. And Justice Clarence Thomas, go fuck yourself. The fact that you would literally send a warning shot to gay people through a Catholic church, I mean, what else is new? But go fuck yourself. Anyway, guys, if you guys haven't already, you guys can go ahead and hit that subscribe button because you don't want to miss out on more lives when it comes to our talk, because I feel like everything is so oversaturated with Donald Trump. We tend to miss the minor details of what's actually going on in our world. And this is a minor detail, and a minor detail, but a major warning shot to the LGBTQ plus community from none other than Justice Clarence Thomas. It was a straight warning shot that we're coming for LGBTQ plus rights. We're coming for gay marriage, and we are probably even going to take it a step further and come for gay intimacy to be codified as illegal and take us back to 1986. That's it. I'm your host of the Silver Point Podcast, Ariana Dieva, and if you guys haven't already, hit that subscribe button, and I will catch you guys on the next episode of the Silver Point Podcast. Bye.